Good morning, everybody. Let's just give a moment. I want to make sure that the YouTube streaming is also going okay. All right, can somebody from my office just confirm verbally to all of us that the YouTube is up and running now, the YouTube broadcast?
It's up and running, Alan.
All right, thank you, Ms. Blanc. So good morning, everybody. My name is Alan Lilly. I'm the presiding hearing officer of the State Water Resources Control Board's Administrative Hearings Office. Today is February 7, 2022. And this is the status conference in the matter of the court's reference to the State Water Resources Control Board in City of Marina versus RMC Lonestar, Monterey County Superior Court number 20 CV 001387. And with me assisting from my office are Amy Blanc, Skylar Anderson, Kyle Woldridge, and Nicole Mullen. And as always, I greatly appreciate their technical assistance. They do a great job on the technical side of these hearings. I couldn't possibly run the hearing or status conferences without them. The Administrative Hearings Office stated in the January 20 status conference order and notice of second status conference has not ordered a court reporter for this pre-hearing conference, and I do not see any court reporter. Did anybody order a court reporter today? All right, we use the Zoom audio plus video recording as our official record of the status conference, and we will post that to the administrative record after this conference. I do see one number here. I'd like the person to identify himself or herself so my staff can put in a name. So whoever is at 619-517-6760, could you please let me know who you are? You have to go off mute too.
Can you hear me now?
Ms. Horning, I hear you with an echo, but there's another tile for 619-517-6760. Is that you as well?
That's me as well.
Okay,
and
then please go back on mute because I'm not sure why, but you're getting an echo. And why don't I'll just ask my staff to put in that number. We'll just put Kathy Horning too. I'm not sure why you show up twice here, but as long as you're on mute, it doesn't bother me. Okay, so we will do that and we will get going. As I won't go over the procedures for the status conference in detail. We just did one a couple of weeks ago, and I'm sure you all remember the process we did for that. If you have any questions or want to say anything, please raise your hand either electronically or the old-fashioned way. Electronically probably works better, and if I don't see it on all the tiles, just speak up if you need to, or wait, I'll try to pause from time to time to give you a chance to speak up. And please do keep your microphone on mute when you're not speaking so we can avoid feedback problems. So with that, let's go ahead and I'll ask for appearances. First of all, who is appearing for the City of Marina?
Good morning, Skip Spalding appearing for Marina.
All right, good morning, Mr. Spalding. Is anybody else appearing for City of Marina today?
Yes, good morning, Your Honor. Larissa Meisenheimer, also on behalf of the city.
All right, good morning, Ms. Meisenheimer. And I don't know if you remember from the last conference, I don't want to have any delusions that I'm a judge or anything. So I try to I ask people to avoid using Your Honor, just use Mr. Lilly, and I'll use Mr. and Ms. to refer to you. I do like to keep it that formal, but no your honors are necessary. Anyway,
Perfect.
Good morning.
And thank you for the reminder.
It's no problem at all. All right, so for Marina Coast Water District, who is appearing today?
Yes, Your Honor. Good morning. James
Oh,
Markman.
Mr. Markham, you already missed. No, your honors, please.
Oh, Mr. Lilly.
Thank
Good
you.
morning. Good morning, Kenny. Yeah, James Markman for Marina Coast Water District. And with me appearing for the Water District are Kyle Brochard, Ruth Musine, Chip Wilkins, and I think that's it.
Okay. Well, good morning, Mr. Markman, and thank you. And who is here for California American Water Company, which, like everyone else, I will refer to as CalAm from time to time?
Good morning, Mr. Lay. Bob, I was having a hard time unmuting. Bob,
We're all still learning. No problem at all. Good
It
morning.
appeared in two different places, and I was trying to figure out which one was the right one. Bob
no
Morales
problem.
Mackins, representing California American Water. Good morning.
All right. And is anybody else here for CalAm today?
Good morning, Michael Betts, also for CalAm.
Okay.
And David Osias, also for CalAm.
All right.
Good morning, Mr. Lilly. Robert Donlin for CalAm.
All right. Good morning, Mr. Donlin. Good morning for all of you, or to all of you.
And,
All right. And who is here? Oh,
Mr. Lilly, just so we don't hear the echo, Catherine Horning is also for CalAm.
okay. Thank you. And I know Ms. Horning appeared in our last status conference as well. So thank you for reminding me. All right. And then who is here for RMC Pacific, which I've referred to RMC Pacific Materials, LLC, DBA, CEMEX, which I'll refer to as RMC Pacific.
Good morning, Mr. Lilly. James Newdecker for CEMEX, RMC Pacific Materials.
Good morning, Mr. Newdecker. And is anybody here today for the Salinas Valley Basin Groundwater Sustainability Agency? We had an appearance for them last time, but I don't see anybody here for them today. And I think we've covered all the appearances. Is there anybody I missed who is appearing today? Doesn't look like it. All right, well, thank you. So a couple of things. I'm not going to go over the whole statement I made last time about ex parte communications. I did want to remind you, though, I'm a big stickler for this. Some might say fanatic or some other word. I just find it's just something. I had some bad experiences during the 30 years that I appeared before the water board with basically what I thought were improper communications between the water board staff that was running the hearing and representatives of one or more of the parties, but not all the parties. So and we do have email now, which works really well. You can add people to the CC line on your emails quite easily. And once we get it set up, we're going to try to have we will have an updated service list, which we sent you with the last order, and we will continue to update that. And that does list the email addresses. So please, even if you're just sending something really simple, like, are you going to post the recording of today's status conference, or something similar to like that, that seems really procedural. Please try to communicate if you possibly can by email. We do have a voicemail, telephone number if you have to, although since we're all working remotely, it takes us a little while to monitor that. Email is really faster. And of course, with email, you can add everyone else's copies. And you'd be surprised. I mean, you may think, well, I don't think anybody else cares about my question about when the transcript's going to be posted to the webpage. But it turns out other people may care. And if they don't, they can delete the email or save it or do whatever they want. So please just try to do that whenever possible. We have another matter where it's getting to the point that some people might think it's a little bit absurd because their IT department is having problems getting their emails to work. And they're working with the State Water Board's IT department to try to clear up that problem. And if it really is something like that, we may digress from the ex parte rule and then just advise the parties when we've cleaned up the problem. But really, for anything beyond that, just CC everybody. And if they get sick of seeing your emails, they can delete them or whatever they want. But I think over-inclusiveness rather than under-inclusiveness will really help us all. So far, I've never had anybody complain about being on the CC line of an email in one of my proceedings. And people do complain when they are not on the CC line. So let's do that. And then, as I mentioned last time, our service list does have mailing addresses where, in case backup paper mailings are necessary, usually they're not. Email just is so much faster and easier, more efficient. And then when we get to posting exhibits, we just, those you can all upload to our webpage, and we will give you the information in the hearing notice. And then we transfer those over to an FTP page that's accessible to everyone, and everyone then can download them right away. And that seems to be a lot more efficient. I know, I'm maybe dating myself a little bit, but back in the old days when we had to send out numerous copies of voluminous pages to a bunch of people, it was certainly a lot more burdensome. So I think the electronic system works pretty well. Of course, then we have an electronic administrative record, which seems like what we want in the 21st century rather than a paper administrative record. So that way we make the administrative record as we go. By the time we get to sending a proposed order to the water board, we should have our entire administrative record already assembled electronically in case any of the board members want to refer to that. The only other thing preliminary I wanted to talk about, we do have these, and I realize all of you are very experienced attorneys, so if I'm insulting to you, please bear with me. I often have hearings where parties not represented by attorneys are participating. But please, any pre-hearing communications you want with each other, there are no limitations on those. And you've all obviously worked very well to prepare the joint statement that you filed last week. And please continue to talk with each other as necessary, whenever necessary, by whatever means you want. And just don't include anyone at my office or the State Water Board as CCs if you're doing those communications electronically. So I'm going to pause there for a minute before we get on to the status conference issues. Are there any questions or comments? All right, hearing none, I will move forward. First of all, thank you very much for preparing the joint, what you called, I think it was called joint party responses to the January 20 status conference order. I appreciate you being able to work together, at least to this extent. It just really helps me to have it all on one page, one document, rather than 4 different documents. So I do have a couple questions. Obviously, my goal today is to try to firm up a schedule for pre-hearing and hearing process, deadlines and dates. And I'll just say, just a minute, Mr. Moore, I do see your hand. I'll get right to you. I just want to say, I have directions from the State Water Board, the State Water Board's executive director, and at least a sense from the court, although I don't think the court has actually said this to me that I know of, but I have a sense from everyone else, they want me to get this thing done as fast as I can. And I'll just say one of the main reasons the legislature created the Administrative Hearings Office was to get water rights matters done. The Water Board had a bad reputation for matters in water rights being delayed for decades, I'll just say. When I started at this new job just over 2 years ago, the very clear directions I received from Joaquin Esquivel, the chair of the board, and in subsequent meetings from all of the other board members were, you've got to get things done in water rights. It's just, the whole system is just bogged down. The state is losing confidence or has lost confidence in it, and so forth. So, and I'll just say that's true, and that is a problem, and we need to deal with that. A lot of times, though, in fairness to the Water Board, I think the parties sometimes aren't in a big hurry to get things proceeding before the Water Board, and that also delays. So anyway, that's tension number 1 that I'm dealing with. Tension number 2 I'm dealing with is, I know from experience, summers become very hard times to schedule matters. I mean, even though you're all attorneys with full schedules, I think I have the sense at least some of you try to take some vacation sometimes, and I do as well. So I just am concerned that once we get into trying to set things in the summer, we're going to have more and more challenges with people's calendars. And, and to the extent I can, I want to respect that, although we do have to have some dates. So anyway, that's sort of my preliminary statement. Before I go on with questions, though, Mr. Moore, you had raised your hand, so please go ahead.
Yeah, Mr. Lilly, I did, but in light of your statement, I think I will wait until later to say what I was intending to say at the very beginning, so.
Okay, well, now you've got me curious, but I'll leave it to you to remember to say it later.
Well,
so
I
that's
can say, well, let me say it. I mean,
Go ahead.
I like to hear myself talk anyway, so.
You're a lawyer. We're all used to that. Go ahead, excuse me.
We had thought, I mean, I don't know right now if the 3 months different we have in these two schedules will make a lot of difference in this case. We'll have a lot of things that we don't agree with, a lot of things less things than we do agree with. We thought in looking at the schedule, the maybe sensible thing to do is for CalAm and CEMEX to agree to the schedule MCWD and the city have, which means a difference in the hearing date of 3 months, which I don't think will make a big difference, especially in light of what the situation is with the Superior Court right now. We would be prepared to stipulate as to their schedule, April 15th, May 18th for the deadline stipulations, August 1st for written testimony, and October 17th for the hearing date.
All right. You did hear what I just said, and obviously you're tempering your comments on that. So thank you. I'm going to ask this. You're all here. This is not an ex parte communication. You may give me different answers, but and just so we're clear, I've had no communications with the court on this matter, and frankly, I don't think I will. I mean, if the court sends me orders, obviously I'll read them and follow them. And if I have questions for the court, I'll send the court communications with copies to all of you, but I don't think it's really appropriate. And I have, again, telling my war stories back when I was an attorney representing parties in water right matters. I had cases where there was a referee and the referee just picked up the phone and started talking to the judge. And I think it really became garbled as to exactly what the issues were that the judge wanted the referee to decide. So that's why I think written communications are very valuable here. But anyway, having said that, does anybody want to say anything about what the court is expecting as far as a schedule from my office and the State Water Board in this matter?
I'll try to answer that. This is Jim Markman again, Mr. Lilly.
Yeah, please go ahead, and I do as best you can.
Yeah, as best I can. I think everyone will agree with this. I don't think the court has quite straightened this out in the court's mind about how we interface with the state board and the court. There's still a trial date that hasn't been vacated for June on a couple of these causes of action. And the city has made it clear to the court that the city would like to do those as is, bifurcated. We haven't briefed that or argued it, but the court seemed very uncertain about what the court wanted to do going forward. I think the court would like the state board to promptly do what the court's asked it to do, but the court, I think, was surprised, I say, that the overall length that we all agreed on after listening to you was going to be months, if not a year or a year and a half, something like that. That was all expressed to the court. So we're going to see the court soon again, but I don't think any of us can say the court pointed us in a direction at the last status conference.
Okay. Does anyone else want to add any comments to that? And I know speculating on what's going on in a judge's mind is something attorneys often have to do, and usually it's very challenging to do. But does anyone else want to say anything more about what their feelings or beliefs are as to what the court may be looking at here. All right. So I will take I don't think Mr. Markman's comments necessarily were in favor of one party or the other. I think they were just basically saying the court's trying to waiting to see what we do to some extent. And I'll just say, one of the reasons I last time said as long of a schedule as I did, was my impression is there's some pretty complicated technical issues here. And of course, I want to work with my staff and I want to resolve them as well as we possibly can, analyze them and resolve them as well as we can. And so I don't want to rush through that process. That wouldn't be appropriate or fair to anybody. So there's going to be another tension here. That's the tension between, it's easy for me to say for all of you to get your work done as quickly as possible, and then I want as much time as I want, and you're probably sort of all looking at it the other way around. So let me just, maybe you've alluded to this some, but I'll just say, based on following up on what I previously said, my inclination as we were preparing for this conference, as I was preparing for this conference this morning, was to actually have a more accelerated schedule than even that proposed by Cal-Am. And what I am intrigued by, if all of you already have blocked out a June 20 date, I don't know, maybe one of you can tell me how many days that was, but I'll just say, if that's all on your calendars and the court vacates that trial date, that looks like a very good time for me to hold at least the initial round of the hearings in this matter. So first of all, Mr. Markman, Mr. Moore, or anybody else, how many days has the court set for the trial that would start if it happened on June 20? Does anybody know?
I don't think there has been any point how long.
Okay. I mean, okay. Go ahead, Mr. Spalding. You're going to try to speculate, which no one else is willing to. So please go ahead.
Okay.
How many days?
I'd speculate at least 2 weeks, maybe 3 weeks. The court has not provided any indication. It, of course, depends on the scope of the claims that the court is going to hear. So my best guess would be 2 weeks.
Okay. All right. Well, I'm not hearing anyone dispute that. And obviously, that's a pretty soft answer, not knowing a lot of relevant information at this point. Mr. Markman, did you want to add something? Oh, I'm sorry. Your box lit up. Go ahead.
No, I didn't have anything.
Okay, that's fine.
I don't know that there is. I think that Mr. Spalding has a good handle on what those causes of action would be, because he's the plaintiff who filed those causes of action. So but I've never heard, I haven't seen an order that says set up 2 weeks for trial, or what you usually see. I don't think it got that far.
Okay.
I do have a reaction to accelerating the schedule, and that is that we were in the middle of depositions and we hadn't got to the expert depositions. And so if we have to essentially turn to answering the questions, all the questions you're dealing with, and have some written testimony ready to submit to you by June, that would be extraordinarily ambitious, so far as I'm concerned. Because other people have, I know, for example, Mr. Brochard is going to be key to working with me in this as a major trial that's going to eat up maybe a third of that time. And so that would be a real rush for our firm anyway. I don't know how others feel. I agree with Mr. Moore. I think if we can stipulate to that's pretty ambitious and realistic.
Okay.
Well, let me respond to that a little bit. I was wanting to, and if I said I'll stipulate to it, I'll stipulate to it, because that's only fair. But I was really planning on there being a fight over a longer period of time, not a shorter period of time. And I thought, giving all the circumstances and the schedule before you, Mr. Lilly, that would probably be okay for both parties. Now, the fact that we can go earlier, I would choose earlier, but again, I already stipulated and I will stay with that stipulation.
No, you're all experienced professional attorneys and you're conducting yourselves that way. And I do really appreciate that. And to some extent, I'm thinking out loud here. I'll just say that it's just, I think one of you, I forget who it was, somebody said they already have a conflict for counsel for the city. I assume that's Mr. Spalding, is not available in September due to a trial in another matter.
Your
is that you?
Honor, Mr. Lilly,
Oh.
that's actually me. I have a 3-week jury trial that's scheduled to start on September 12th.
Okay.
If that September date is, or somewhere in September is a date that works for most people for the hearing, Mr. Spalding is available, and we do have other attorneys at our firm that have been involved in the case.
Okay. Unfortunately, it looks like I'm going to have another matter in September as well. So that's, and I mean, it's really hard to do this. I'm very concerned. Once we beginning of, we're going to be into October. I'm concerned.
Well, Mr. Lilly, let me suggest something.
Okay, go ahead. I had a couple of questions. Go ahead.
We care about our date. We're done August 1st. If it's, and we left you 6 weeks or so to, well, longer than that, to deal with when the hearing would occur, because you'd have all the materials. So if you advance your hearing schedule, we're done. We've submitted all this testimony to you already. That would be completely up to you. I don't think Bob would care either if you advance the hearing date. That just eliminates some of your time that we gave you.
Right. So
I'm not sure I quite understand that. Are you saying where you have October 17th at this point in time, that gets moved up to an earlier date in August?
If that's what, well, not August, but you have all of September. And if Mr. Lilly can move up the time he has the material to the time he's going to conduct his hearing, really, that's up. I don't see how we would object to that. That's all I'm saying.
Well, the only thing is, I mean, I just have to read the material and get familiar with it so I know what's going on. But you have to read the other side's written proposed testimony and prepare your cross-examination questions, which might take you more prep time than me. I mean, you're all probably pretty familiar with these issues. So I'm going to ask a couple of other questions and then we'll cycle back to this. I'm wondering, well, first of all, I'm not sure what order to ask these questions in. I'm going to first ask, and I'm going to start with, let's see, I'm going to start with City of Marina. Mr. Spalding, this is your case, as far as I know. You're the plaintiff in the underlying case, so I'm going to start with you. If that's not right for how the Administrative Hearings Office will handle this, you can let me know. But how many witnesses do you anticipate the City of Marina is going to be calling?
Mr. Lilly, at this point, we're not positive. I think we're in the range of 2 to 3.
Okay, and of those, how many are expert witnesses that will be giving opinion testimony?
2.
All right.
Tentatively.
All right, and I'm not holding you to this. This is just to try to plan. None of this stuff is commitment. All right, so Mr. Markman or somebody else from Marina Coast Water District, how many witnesses do you think you will be calling, and of those, how many are experts?
I think I'll defer to Mr. Brochard on the mechanics of that.
Okay, Mr. Brochard, please give what's your estimate?
I believe that Marina Coast will likely call 4 witnesses and 3 experts.
You mean 4, and of those 3 are experts?
Yes.
Okay. All right. And so Mr. Moore or somebody else from Cal-Am, what do you see?
As everyone has said, it's difficult at this point in time, but I would guess we're talking about 5 witnesses, and probably 3 of those witnesses are experts. I'd ask Mr. Osias, also, or Mr. Betts, if they agree with that, because we haven't really sat down, obviously, at this point and mapped out exactly how we're going to try the case. But that's probably a fair estimate of the number of witnesses we're going to have.
All right, so Mr. Osias or Mr. Betts, do you want to say something different?
No, that's as of today, that's as good a guess as we could come up with, I think.
Okay, and then so let's see, you've moved around. Mr. Newdecker for RMC Pacific, what do you see for number of witnesses?
Probably one witness, and will likely rely on expert witnesses produced by other parties.
Okay, so one non-expert witness. Okay. All right, and then as I think I said last time, normally for water board proceedings, and I don't want to sound like an old veteran or anything, but I did well over 30 of these, maybe more like 50. I never once took depositions of any witness before I did a water board water right hearing. I never thought I was at a disadvantage for having not done that. And the reason is that I had the written proposed testimony, and the hearing officers required the parties to stick to that. And I certainly will here. You all know what it means. Summaries mean summaries, not adding a lot of new testimony on new topics. But having said all that, how many depositions of, well, I'll just say in total, do all of you anticipate taking for witnesses that are going to be testifying in my hearing? And I'm not particularly interested in the court proceeding, which you may have different witnesses. All right, so Mr. Donlin, I see your hand is up. Go ahead.
Yes, Mr. Lilly, and I'm not proposing to answer the question that you just posed, but I did want to ask, because I think it will help the other counsel in this matter to answer your question. Do you intend to have a rebuttal hearing phase?
It's on my list here to talk about. The answer is I intend a little later on today to ask the parties if they think rebuttal is going to be necessary. So that's, and after I've heard from them, then I can answer your question. I mean, it's a fair question, but my guess is, this, knowing the complexities here, that parties will want to submit rebuttal evidence. I'm not sure, but it seems pretty likely. So the answer is probably, unless all of you tell me you don't think that's going to be necessary, and I seriously doubt you're going to say that. So, okay, let's go forward with depositions. And I'm just going to go in the same order. I guess my question is, and this really is more a sense of how much time do you think you need before the deadline for submitting written proposed testimony and exhibits? So again, I'll just ask, does anyone want to volunteer first? Is anyone planning on taking depositions of any of the other parties' witnesses that are likely to be designated for this hearing? I'm not seeing any hands going up now.
Let me,
Mr. Moore.
Yeah, if I understand your question, and I think I think we had probably, Michael, you tell me if I'm wrong again, but 6 depositions scheduled, but they've all been taken off calendar. As for, they weren't experts, but they were witnesses most knowledgeable about different things for each of the parties. I doubt that those witnesses will be called in this phase, or this part of it. We do have experts on both sides that will be deposed before they give their statements here. And that's probably in the range of 3 to 4 for us.
So that means you previously, if I wrote this down, you said 3 experts. So are you saying your experts are likely to be deposed, or you're likely to want to take depots of the other party's experts?
We will want to take the depositions of the other party's experts. And at this point in time, I can't tell you what it is because they haven't been disclosed.
Okay. Well, that's certainly fair. But if you have their names, then obviously you can notice their depositions, and we can go forward that way. Mr. Wilkins, please go ahead.
had a question about the witness disclosures. When they're released, is it just the names that will be released? Will we know what they're planning to testify on? I assume there are no expert reports for experts, but I just wonder how much we'll have to figure out about what a person might say if we don't take their depositions.
And the answer is our normal form is when each party files their notice of intent to appear at the hearing, which I'm sure all of you will do, you have to list your witnesses and just state yes or no as to whether they're going to be expert witnesses, but nothing beyond that. So the answer is, from my point of view, you won't know what they're going to say except for the fact that you may have all interfaced with these experts before. I don't know. Maybe you have, maybe you haven't. So you would know that. But the answer is, Mr. Wilkins, just names, nothing more. And we've never done more than that. And frankly, I mean, I can see where it would be useful to you, but I can also see then at the hearing, inevitably, people are going to argue about whether or not what the witness actually testified is within the scope of what they were designated as having testified to. So that's why we normally don't go down that path. I don't know, your hand's still up. Do you have a follow-up question, Mr. Wilkins? Or okay. All right. So, okay. Well, I'll just ask whoever wants to. Okay. I don't know if anybody finished that. I sort of heard that it looks like Mr. Moore is at least planning to depose the other party's expert witnesses. I didn't hear anything from anybody else, and I don't know. Mr. Markman, Mr. Wilkins, Mr. Brochard, if any of you want to say about whether or not you intend to take the depositions of the adverse party's expert witnesses.
I highly encourage that if Callum is taking our experts' depositions, we will do the same.
It seems fairly likely.
One clarifying question. When we're talking about expert depositions, procedurally, are these things that take place after the disclosure, that before the testimony, or after the testimony is submitted?
You know, it's a good question. And I'm trying to remember, we do have a court, the reason I'm fumbling a little bit here is we do have a pending court proceeding, and we have some advantages. We can rely on some of the applicable provisions of the Code of Civil Procedure, which normally would not apply here. It's been a while since I have done this. I'm pretty sure it's section 2034 of the Code of Civil Procedure, but can somebody just tell me what you have to state in that? Or maybe I should just get it out. But as I recall, expert reports are optional, but you do have to disclose something. So maybe just bear with me 1 minute. I'm going to get my copy of the Code of Civil Procedure. You can see I'm a little rusty on this stuff. It's been a while. Okay, so there's the expert witness declaration under 2034.260, which I assume is what we're talking about here. Names and addresses, blah, blah, blah. Okay, so we're looking at, I think, somebody tell me if I have the wrong statute, but I think this is it. 2034.260 subdivision C is the declaration shall state the following: a brief narrative statement of the qualifications, narrative statement of the general substance of the testimony, a representation the expert has agreed to testify, and a representation the expert will be sufficiently familiar to submit to a meaningful oral deposition, and a statement of the expert's hourly and daily fee. Is that the I assume, Ms. Meisenheimer, I'm sorry if I'm a little slow here, but is that the statute you're referring to here for declarations?
Oh, so when you're in state court, that is the statute that governs the declarations that are served. I wasn't sure if we're following the same procedure here in this proceeding, but my question really was sort of timing of depositions. Given that we're submitting the testimony in advance of the hearing. It sounds like what you're envisioning is the depositions would occur between the disclosure and when the testimony goes in, but I wanted to make sure we understood.
Well, we're in, first of all, yes, these are the state court proceedings, I mean, state court rules, and this is a state court proceeding. We're certainly not going to follow the federal court rules, God forbid. We're really on new ground here. Certainly, this is the first court reference my office has received. And the State Water Board doesn't receive very many of these. It has not over the years. And I'll just say, I think in the past, they've tended to be more informal, you know, where the staff may go out and kind of just go meet with one party and talk to them and go meet with another party and talk to them and then prepare a report. And I really don't think that's the appropriate way to go forward here. I mean, this is a formal, I'll just say, hotly contested or strongly contested. It's a formal trial proceeding with some very hotly contested issues. Of course, I have no idea how I will recommend to come out on those, what the water board will do or what the court will do. But I think the formal proceedings are more beneficial to the parties and me than some kind of an informal process here. And that's why I've planned to go forward that way. Now, I mean, the way this statute is set up, I mean, clearly the declarations have to occur before depositions occur. Whether they occur before or after written proposed testimony, I mean, the written proposed testimony to some extent is what the water board normally does instead of having depositions. So, but that's why I wanted to get your input as to whether or not, I mean, I have some discretion here, and I'd like to do what is fair to everybody and makes the most sense for going forward. I think I can set a date to require parties to provide these declarations that are required by this statute. I think I can set a schedule for depositions. Obviously, then you can schedule them within that time frame, and a deadline for submitting written proposed testimony. Or we could just have these disclosures, and then you could file your written proposed testimony. I guess then you could have depositions after that if you thought it was necessary. I mean, frankly, they'd probably be a lot more efficient if you had the parties' written proposed testimony before you conducted the deposition. Then you could just ask them about that. And that, frankly, could save a lot of hearing time and maybe really focus matters going forward. So I'm sorry, I'm brainstorming here. I'm throwing out concepts, and I'd like input from all of you as to what you think makes sense here. And since Mr. Wilkins put his hand up, he gets to answer first. Go ahead, Mr. Wilkins.
Actually, I have a question, and then I'll give you my brief thoughts on your question. My question to you is, when we were discussing the written testimony, you had analogized this proceeding somewhat to a CPUC proceeding in our previous conference.
Right.
And it's our experience that when you submit testimony in those proceedings from experts, you generally will provide some basic qualifications and stuff in their testimony, and then you'll largely attach an expert report almost, or some type of memorandum that expert has provided with their opinions on the subject. And I was curious if that is what you envisioned here. And then assuming that basically we're going to get an expert report in the form of written testimony, I think it would be much more efficient to take depositions after we receive that.
That's sort of, well, let me answer your question first, and then I'll give my comment. Normally, well, first of all, our standard hearing notice does require parties to submit statements of qualifications of their expert witnesses. And that's sort of goes without saying. We want to know what the qualifications of the witnesses are before they testify. Most experts write out more of, I'll call it a narrative written proposed testimony, although some do have a very short narrative testimony, which says Exhibit 57 is my technical report for this matter. And That's it. And that's fine with me. At that point, the technical report is authenticated and essentially is part of that witness's testimony. And I mean, from my point of view, then my office and the board may rely on that as evidence, subject, of course, to all the rules of evidence. But we may treat it as if the witness had testified and read that whole report. And of course, we don't want them to do that, just from a time point of view. So I have seen that done, and frankly, sometimes that format is just a lot easier for technical experts to follow, and I don't think there's any problem with that. So before I go to you, Mr. Osias, Mr. Wilkins, does that answer your question about how we proceed? So I guess I'll say that the PUC model is one model we can follow, but it's not the only one for expert testimony.
Yes, thank you.
All right, so let me go on to Mr. Osias, and then we'll circle back. Go ahead.
So I had just a couple points, perhaps more procedural than anything.
Go ahead.
I do recognize the uniqueness of this proceeding in terms of history, that we haven't had a reference and a hearing officer combo in my 40 years of practice. So I think you probably can do whatever you think is reasonable. And I suspect also you're going to get agreement if we conduct brainstorming publicly like this. Second,
well, that's my goal. I mean, again, here, I'm not trying to give anyone any advantage.
Right.
My goal is as efficiently as possible to get all the relevant evidence before in the record so that I can reevaluate. Anyway, go ahead.
And I was going to say that the CCP section on experts that we all just quickly looked at is useful as a tool. I would also suggest if you needed another model besides the PUC model suggested by Mr. Wilkins, we have the more recent, at least in my lifetime, more recent groundwater adjudication rules adopted in the CCP, starting with section 830, but there's a specific provision on expert witnesses at CCP section 843. It gives a judge in a groundwater adjudication great discretion. It has a sort of a default rule that you identify the expert and exchange reports, but it also says the court can not require that and just an identification and the topics and the qualifications, sort of like the other. And it does have some suggested timelines, which a court can vary, as therefore you could. So if you were looking for another set of examples in a water setting for expert witness matters, you could look to 843. Also interesting, the legislature decided to put into groundwater adjudications the ability for a court to take testimony in the form of written testimony, a practice that the state board has used for years, and that's in 844. So
they may have been thinking about the State Water Board's practice. The people who wrote that. One of my former colleagues was involved in some of the drafting. I don't know whether or not that, but it certainly is possible. And I will just parenthetically say, sorry for interrupting, but I think it ends up being a much more efficient process than if witnesses just testify. I mean, the other parties know exactly what the witness is going to testify because it's all written out. The witness can write it all out, which is a lot better than having to give it orally. I mean, when witnesses give oral testimony, either they read it, which is pretty dull, or they talk, which means that it's not as technically accurate. And frankly, it's also really a benefit for the hearing officer to be able to go back and read well thought out, organized, written testimony rather than having to go to a transcript or a recording or something like that. So it is a benefit all around, and maybe that's why the legislature ended up with 844. I don't know. Anyway, go ahead, Mr.
Well, and now, my last comment was going to go to sort of the topic that Mr. Donlin had raised with you, and that was already your question. And I think in this kind of structure, rebuttal and under 843 impeachment, if you have the distinction in mind, I'm not sure it's always obvious, for experts is relevant and I believe would be useful in this case.
I think so too. I mean, that's when you start getting to the nitty gritty of how solid different opinions are. It's when they're, well, you do a cross-examination to start with, but that, you know, well, you all know how
Right.
the limitations of cross-examinations, but then if witness A says, you know, I read witness B's testimony and here's where I disagree and here's why. I mean, that's the type of testimony that ends up being very valuable for the hearing process. You sort of, you know, really get the responses back and forth. And, you know, of course, it still often is very challenging to figure out what to do, but that's the best way to get it all on the record.
Right.
So,
and my point was that's just contemplated in section 843. So at your leisure, you can look at that as a model if you thought it was helpful.
yeah, I know I've read it before, but it's been a while. And I'll confess I don't know if anybody's actually had a court proceeding that's gotten that far. Has anybody?
Yeah.
You have? Okay. Good.
The Ventura River adjudication's in that process right now.
Okay. All right. Well, I think we certainly do. I have discretion to decide what procedures to follow. I certainly am far more comfortable following some statutory procedure than making one up on my own, because obviously someone else has spent a lot of time working on it. So I don't know, Mr. Moore, did you have another question or comment? Go ahead.
Yeah, I did. And we already have a procedure. The court system is a procedure. You identify who the experts are. You identify what they're going to testify to. The first thing you ask them when you're deposing them is their background, their experience, and what opinions they're going to offer. And at that time, if not earlier, they'll tell you exactly what and they'll be held to that at the time they try in the Superior Court. So we'll have all of that without ever impinging on your proceedings. And unless there's some kind of problem in the proceeding, they need something else, but that's already in place. And that's been proven to be fairly efficient, I think. And it's certainly more efficient than having two different procedures in place, one before the board and then one in front of the Superior Court. And going through those procedures, I think in the Superior Court, they really do cover everything that we will need to cover. Certainly before they testify or they submit their report. But that is the way, and regardless of whether we come up with something else or not, that's the way the Superior Court's going to do it. So if we don't use that, it's pretty much wasted for us. And it seems to be, if it needs a little bit of tweaking to make it more easy for us to use and before the board, that's one thing. But to abandon that entirely, which it sounds like people are talking, to abandon that entirely in a procedure that will happen. There's no question it's going to happen, because that's part of what the trial court's going to do, I think would be a mistake. And I think fairly inefficient.
All right, before I get to you, Mr. Spalding, first of all, I'm very familiar with the 234 process. I did that many times in my career. And I agree with you. I think it's pretty darn good about getting out the experts' opinions. The problem I used to find was if, 30 days before trial, the expert would say, well, I haven't really finished my analysis. I still have to do this, and that. And, and unless the court really held them to it, the expert sometimes would not finish his or her analysis and opinion until the morning of the trial, which that was sort of a deficiency of the deposition procedure. And then, of course, people can argue back and forth about whether that's allowed and so forth. But from Mr. Moore and Mr. Osias, I'm hearing a little bit of conflict between what you're both saying, which is a little bit of a concern to me, because if I have my names right, you're both representing the same client.
Yes, we are.
Mr. Moore, let me reconcile them in a moment. One, I wanted to just make sure you were reminded of 843, okay, in light of the comment about the PUC as a model.
Okay.
Second,
well, let me just say, I think 234.6260 applies here. This is a court proceeding, so that would apply. I don't think 834 specifically applies because this is not a Sigma case.
Correct.
Now, and you didn't say it did. You said it could be a model. I understand that.
Okay.
But then Mr. Moore sort of seemed to be saying we should use 234 because that's what applies here. I don't know, the two of you need to be talking a little bit more. I
No,
guess.
we can, here's
No,
the
this
point.
always
that I
happens
think
this way.
here's what happens. Okay.
Go ahead, Mr. Osias.
Yeah, I was going to say, Mr. Moore brings up a point that wasn't particularly at front of my mind in listening to the dialogue up to the point I made my comment, which is because this is a referral and ultimately the decision in the case will come from the court. The court process is going to take place. And so his suggestion is to have two different processes makes no sense when ultimately we know one process will have to occur in the court, which is the normal one that he described. And therefore maybe using it is, I think his words were more efficient. I tend to agree now that I've been reminded that in fact, we're going to have the court process anyway.
So before I get to you, Mr. Wilkins, Mr. Osias, while you're at bat here, did you anticipate that there will be expert witnesses for the parts of this case that the court will hear in the first instance and that have not been referred to the State Water Board?
I would pause because of the words first instance. I doubt that the court would hear the expert witness testimony before the State Board referral process is completed.
Okay, and if I wasn't clear, I meant on other issues that have not been referred to the State Board. Does your answer still hold? But I mean, of course, the court's going to let the Water Board do its process on the issues that the court referred to the Water Board. That's why the court referred them. But I don't know enough about the case. Are there other technical issues in the case that have not been referred to the Water Board on which expert witnesses may be necessary?
It's hard for me to identify any at the moment off the top of my head that don't relate to the questions that the judge asked.
Okay, I'm not holding you to it. I'm just trying to get an answer. All right, I mean, just a feeling for this. All right, so we have Mr. Wilkins and Mr. Markham. You both have the same client. Who wants to go first?
Let me go first, Pete. So let me go first, so then I can get straightened out if I'm wrong. But I think we're talking about two different processes here. This doesn't make sense. But we've talked about submitting this testimony, and then we've talked about, I think, a good idea, which would be to have depositions after that, because then we'll have this testimony, which is as good as an expert's report, maybe better, and we can really hone down the issues that are actually going to be left by the time you have a hearing, because we will have deposed each other's witnesses on their first set of testimony already. It'll sharpen all the issues up. That's one process. Seems to make sense. And I think Mr. Wilkins was correct saying if we're going to do it in the context of the State Board reference, let's do it after they submit. And we just so happen to have 2.5 months in our dates that we gave, August 1st, October 17th hearing. We could do these depositions in August after that testimony is submitted, still have time to prepare for the hearing. However, now, Mr. Moore is correct, unless the court will essentially say this is all part of your reference, all these expert depositions go in that context. You have a different process. The hearing officer has set those depositions for after submission of the written testimony. And so he can, in his authority, he can stop the other process from happening in the court context. So we don't want to do this twice. And I agree, there are two different processes. Let's pick one, because I have no doubt that if you don't set one up, then we're all going to be at each other doing expert depositions before June or whenever certainly before submission of this testimony. So I think that makes sense to do it. We have a schedule that would allow for it. If you want to set it up, we're going to go talk to the court about this anyway. What do we do about expert discovery? We have a different process over here. I also want to ask that last question, a quick statement, Mr. Lilly. the first causes of action, there are two causes of action in here that don't have all of the questions submitted by the court to you, but I'm sure they have a few of them. I'm sure there's going to be testimony about location of water that's being extracted in a very general sense, in many senses. And that has been asked in your set of questions. And that applies to the first few causes of action. That list could be changed by the trial court when the trial court finally decides what to do, if the trial court's going to bifurcate causes of action. But that complicates also what we've just talked about on depositions.
All right, well, let me say, I mean, my impression is the trial judge has some discretion here, and if when the water board finishes its report of reference and sends it back to the court, if the court thinks more discovery is necessary and more testimony is necessary, either on the issues the court has referred to the state water board or on other issues in the case, I think it's pretty clear the court has discretion to allow additional discovery and so forth if it wants to wrap up the court proceeding. So I don't think that's going to be a big problem. I was just trying to think from an efficiency point of view. So anyway, we're going, this is very productive and I appreciate everyone's comments. I think everyone's trying to be constructive here. Mr. Wilkins, having heard what Mr. Markman said, is there anything you want to add?
No, that was basically what I wanted to add.
Okay, good. Well, I'm glad the two of you are in sync. So Mr. Moore, back to you. Your hand is up.
Thank you. It seems to me that number one, whatever we do here, later on, the court can accept or reject on the rest of the case when it's being tried. So we may probably not walk into something we had all the what we thought was really an efficient way to do this. Have the court say, I'm not going to adopt any of that, and you can take these depositions all over again if you want to, given the circumstances.
That's going to be up to the court, and I don't think. I mean, and that's going to depend on what the state board's report is and what the parties say about it, I think.
Yeah, but my only thought is if we do it one time in front of the judge, in that case, I think the way to do it is for us in this group to stipulate as before the judge how we're going to proceed on those depositions. So we have then one procedure, and that's the procedure in the Superior Court. The way we proceed down in the Superior Court, and I'm sure the court would say, if you guys are going to stipulate, I'll agree to stipulate. And then we proceed over there, and when it's done, it's going to be in a form that we can use it here and a form we can use it there, because the court has already blessed it. I can't give you right now how we do all that, but I think there's a way we could do it. And
okay, let me just say, Mr. Moore, I want to be open about this so we can get through this. I don't think that's a very good idea, and I'm going to just say that. And the reason is that the court sent this to my office to deal with now, and I don't think the court really wants to. I mean, I don't know, but I don't want to prevail on the court to preside on discovery for the testimony before my office. I think it's up to me to figure out how to do that. Of course, this is all subject to later review by the judge, but I think the judge gave me issues to handle, and I want to handle those myself. And of course, if anybody thinks I'm doing something wrong, they can file, let me know. And if I disagree, they can ask the judge for whatever relief they think is appropriate. I don't know what the judge would do, but let me just throw out what I'm hearing here, because I think it's maybe a blend of what I've heard from several of you. Although I'm not that I agree with Mr. Markman on everything, but I think he may have been on to something here. It seems to me like a reasonable stepped process. And again, I'm thinking, centric from how my process normally works. We can have the date for designation of experts, which is, that's really just names. That's not going to be a lot. Not a lot of work, not a lot of information. So that presumably can be fairly soon. CalAm and CEMEX had proposed March 1st. MCWD and the city had proposed April 15th. Deadline for stipulations, that's sort of a collateral matter. Of course, anything you can all stipulate to, that's great. That makes our hearing process more efficient. Then we have the deadline for submittal of AHO exhibits and what you call written testimony. I call it written proposed testimony. It's the testimony that's then affirmed by the hearing. And then I'm hearing that I think what Mr. Markman said, which is, I think, a pretty good point, is that written proposed testimony referring to the exhibits that you're going to submit to the AHO for our hearing anyway, that really is a substitute for a normal expert witness report. I mean, it may be more detailed, and it's in the format. It's like, okay, look, this is the way it's going to have to be presented at the AHO hearing, because that's what the witness will do. Is this your testimony? Yes. And maybe a brief summary, and then we get right into cross-examination. So I think that will make that, I think those 3 steps will really help focus this process and get it going forward in the most efficient way process. I think I'll just say, I think that's more efficient and focused than the CCP 2034.260 process, which we don't have to follow here. And then the only other step that it comes into the schedule is if any of you think depositions of these declared or the witnesses that have submitted the testimony are still necessary. And frankly, I have countervailing considerations. I'm a little concerned about the time that'll take. You've heard me talk about time. But on the other hand, I think there could be a real benefit. I mean, if you go through somebody's written proposed testimony during a deposition, you can ask a lot of questions on cross-examination and kind of weed out the points you want to ask during the hearing and the points you don't want to ask during the hearing. If that makes the hearing go more efficiently, I'm totally in favor of that, obviously. And you can really focus then on the pertinent issues. So if that's our process, first of all, if that's what I'm going to do, it basically would be from your joint statement, 1, 2, 3 would be the same. There'd be a new, what I'll call step 3.5, and then we'd go to step 4. And we'll talk about the dates in a minute. I think that might be the most efficient way to go forward here. I think we have, between the court statutes and the water code statutes, we have the authority to order, I have the authority to order that. But frankly, I think that's efficient. So does anybody have any comments on that, on what I just said, whether you agree or disagree? Let's not talk about schedule yet. Let's first talk about steps, and then we'll come to schedule next. Does anybody want to say anything about that?
Of course, Mr. Willoughby, I agree. I agreed to suggest it. I think it makes a lot of sense. And what
Good. Well, it was basically your proposal, so I'm glad you agree at least.
Yeah.
Get off to a
We
start.
agree, Your Honor, for Marina.
Excuse me? Oh,
Skip Spaulding. We agree with Mr. Markman and with your proposal.
okay. Sorry, I'm just sort of jumping around with tiles here. So thank you, Mr. Spaulding. So Mr. Moore, Mr. Osias, Mr. Wilkins, or not Mr. Wilkins, you're, sorry, wrong party. Mr. Moore, Mr. Osias, does either of you have any comments on that?
Well, I'll only say, Mr. Lee, I think there still remains a problem. The Superior Court is going to have other issues, and it may allow depositions of experts on other issues. I think that, well, I said what I had to say about what I thought was the most efficient way. I know you'd rather do this, so I'm not going to say anything more, but I think it creates a lot of problems. I mean, the main, obviously, adjudication is going to occur after your recommendations, and you can take, court can use them any way it chooses to. That judge is going to decide this case. And that judge may have a lot of other things interested, and we may have a lot of other things we need to say to them at that point that are not pertinent to what we're doing here. So that's why I said I think the easiest way is to almost like have 2 different routes, one route being Mr. Markman's route and one route that stays basically in the Superior Court. I would choose the Superior Court. Let's put it that way.
Okay. And Mr. Moore, the reason I'm hesitant to do that is then your depositions have to cover issues beyond those that the court has assigned to the AHO. And they become broader, and there could be a mismatch there. I think, maybe I'm looking at it selfishly from my point of view. I want to get through my proceeding, and then the court can, I don't know what the right analogy is, take the baton or whatever. Hopefully we've narrowed the issues considerably. But if the court concludes that the water code provides for hearings on exceptions to the referee's report, obviously, and there are other issues that the trial court has not even referred to the water board that it's going to have a trial on if the parties can't resolve those. And if there has to be discovery in connection with that, the trial judge clearly has discretion to set up a schedule for that. But that's why I'm thinking I want to get through my proceeding as efficiently as possible. I think that's what the court wants me to do. And then the court will obviously have to figure out where to go from there. So anyway, that's why I'm inclined to do it that way. And again, these are judgment calls. After we're done, we can look back and decide whether it was the right thing or not. But that's the way I think I'll go forward here. So
I understand, Mr. Lilly. You have to, if everyone agreed, and I just don't agree. So
well, that's fine. That's we're lawyers. We can't be expected to agree on everything or even many things. So thank you. All right. Well, if we do that, what I'm going to call steps 1, 2, 3. I guess I'll just ask, if we have that process, do parties think they're going to want to take depositions? And I realize you may not know until you see the written proposed testimony from the other party's experts, but do people think they're going to want to take depositions of the experts that have submitted the written proposed testimony before the hearing starts? Raise your hand, yes, or
yes.
Raise your electronic. And Mr. Moore, Mr. Newdecker, Mr. Spalding, you're all saying yes. You're lawyers. You don't want to waive your rights. I understand. Okay. So, and that's fine. This is complicated. Frankly, I think it's in my interest if you take the depositions, because hopefully then when you get to the hearing, your cross-examination can be much more focused. You know what questions work and how you can make your points, and you don't have to essentially do some discovery during the process of the hearing. I think that will be more efficient for me, but it will take more time. All right, so I'm coming down to thinking I need ultimately to decide on a schedule here, and for shorthand, I'm just going to call it steps 1, 2, 3, 3.5, and 4. And we need some dates. So I'm going to start with step 1. How long do people need to just file? This is what we normally do as notices of intent to appear in our water right hearings, which just, you have to list your name, the attorneys who are going to represent the party, and the witnesses the party plans to call, and then yes or no as to whether they're expert witnesses. It doesn't seem to me like a lot of time is necessary for that. I see March 1 and April 15. For March 1, I certainly get that. So Mr. Markman or Mr. Spalding, do you have any comment on why March 1 would not work for step 1?
Mr. Lilly, our thinking was that we have a CMC with the court on March 29. And at that point, the court is going to either grant or not grant the bifurcation motion, and will presumably be clear about what he's going to try separately, or if he's not trying anything separately. And we were thinking that really until that point occurs, it's very difficult to know, particularly for Marina, what the scope of the witnesses is in this proceeding. So we were interested in providing a date 2 weeks after the judicial conference.
And I guess I don't understand that, Mr. Spalding. I mean, you know what issues the court has referred to the State Water Board. And again, maybe I just don't know enough. I'm sure I don't know enough about the court proceeding, but why does how the court rules on a bifurcation motion for the court's proceeding affect the witnesses and the scope of the hearing before the Administrative Hearings Office?
Well, from our point of view, it makes a difference on to what extent will be part of this proceeding. If the court retains all of our claims and the questions relating to those claims, we obviously, and we're not participating in any way in this proceeding, that actually makes our list quite different. So from our point of view, it would be a benefit if you would like the names earlier, we can certainly do that, and I suppose withdraw them later.
I think that would solve that problem. Again, I don't want month and a half delays in every step if we don't need them. So yeah, I certainly, if you say you're going to participate in the hearing and then something happens in the court proceeding, you no longer need to participate in the hearing, you can say, I withdraw my notice of intent to appear. I am pretty confident that Mr. Osias and Mr. Moore would not object if you did that, if you withdrew your notice of intent to appear after filing it. So, okay, well, I'm hearing, based on how quickly I can get a notice of hearing out, that March 1 makes sense for the deadline for expert witnesses. So let's go on to step 2. I was a little, well, I don't know, and maybe this was sort of, you were looking ahead to the hearing dates, but you all put down May 18 for stipulations. And I'll just ask, and I have no idea what you might stipulate to, but why did you put that time frame? I mean, that's still from today, that's over 3 months down the road. I do understand attorneys sometimes take some time to work out word by word stipulations of fact, where every word does matter. But does anyone have any comment on that, or basically, can we move that deadline up?
I have a comment, Mr. Lilly. I don't know
Go
why.
ahead.
I don't know why we ever. This has been bothering me from the first time I heard it. Why would we constrain ourselves with a limitation on the timeline on entering into stipulations? Why don't we just leave that open? We can reach stipulations months later, even right up on the eve of trial, if that's what we can do. That can be helpful to everybody, if there's something to which that would be stipulated to. So I don't understand the constraints. The idea there was to get some of this done. It might change the shape of the trial or the length of the trial, number of issues, but we can always do that. And I would hate to say, well, call David and say, look, I have a couple of things in mind. And he says that we can't do that anymore. We ran out of our own timeline. Now we have to move you, Mr. Lilly, or the court to reopen our ability to stipulate. So I don't know why we need that.
Well, the reason it was, and I don't know whether it's my fault or your fault that it's in there now, but it doesn't matter. The reason I thought a deadline was useful was then it could affect what you had to submit in your written proposed testimony. I mean, if you stipulate to things, you don't need to have witnesses testify to them. I agree with you, though, if you come up with stipulations later, and as I've said before, you all are professionals, and I think you're pretty good at focusing on where you have disagreements and not bickering over collateral points where you don't have disagreements. And you've all been doing this for a long time, some of you even longer than I have. So it seems like that it is good to have a deadline, though. Well, let me throw this out. I've never had a deadline for stipulations in any other hearing notice I've sent out. And maybe it's wishful thinking to think there are going to be any stipulations here. So, Mr. Wilkins, your hand is up. Go ahead.
I think there likely will be some stipulations. I guess maybe to rephrase it as stipulations for proposed testimony or something like that, just to make it clear that we should be submitting our stipulations for use in testimony to the extent possible by that date, so the parties will meet and confer, and we can all shoot for that date. But I agree with Mr. Markman. We wouldn't want to limit ourselves if we all agree on something later that will reduce your time and the cost of the parties.
I particularly thought, Mr. Lilly, there might be, after what's happened today, I can imagine some stipulations might occur after phase 3.5, after those depositions and the initial testimony submitted. It may be.
And that's good. I mean, anything, if you can make the hearing more efficient, I'm in favor of it. And if you can make the things we have to analyze and decide in our proposed order narrower, obviously I'm in favor of that too. So, okay, Mr. Osai, this is sort of like more of a target date than a deadline is what we're talking about. Mr. Asias, your hand is up. Go ahead.
Yes, so as to the last point, I don't think it's stipulate by X date or don't ever tell the hearing officer you've reached agreement on something. That would be a silly rule. And on the other hand, going to the narrowing, I mean, at the risk of being proven wrong, part of the judge's questions are, where are the district's wells? I mean, you know, we probably should be able to stipulate to the location of the wells, at least the surface location.
Well, we ought to
therefore,
we should say be able to stipulate on where they're perforated and all the rest of that, and not just our wells, your wells. So,
well, our wells aren't in existence, so I can just.
All right, you guys don't start arguing the case. We're going to have
No, but my point is, going to what you said, some things wouldn't need to be in the testimony if they were agreed upon before the testimony is due.
Right. What I'm hearing is whatever date we set for the deadline for filing written proposed testimony and exhibits, we should probably have a target date of 30 days earlier for the parties to file stipulations, so that then you can refine your written proposed testimony and decide what exhibits you need to file based on the stipulations. But it's a target, and I think it's still useful to have a target, just so that you all have the same schedule, and then you can go forward from there. So I'm going to change that to a target and just basically say 30 days before whatever we decide on as the deadline for submitting written proposed testimony and exhibits. So let me write that down. All right, so now we get to the hard ones. Step 3. I think we now have a pretty good idea, at least I do, of what needs to be filed by the deadline we specify for step 3, and that is written proposed testimony. And it really does need to cover what your witnesses are going to say at trial. And I just cannot emphasize this more than I'm trying to right now, because every single hearing I've presided over, somebody comes forward, usually parties who are not represented by any attorneys. And the witness, whoever it is, says, basically has a whole new written statement that sort of might be related to what the witnesses submitted as written proposed testimony, but starts to read a new statement. And inevitably the other side objects and says that's not within the scope of what they filed, blah, 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 blah. And it's a waste of time. I feel bad about having to tell people they can't testify. But on the other hand, in fairness to the other parties, they didn't have notice of that. And the whole point of this process is for people to have notice of what the witnesses are going to testify on direct. So I'm sure I'll say it again when we get to a pre-hearing conference, but please, whatever your witnesses put in their written proposed testimony, that's it. And a summary really means a summary, as in summarizing paragraphs 1 through 6. I went to Acme State University and got my degree in civil engineering on this date. Since then, I've worked for 30 years in this field. Summarizing paragraphs 7 through 12. My general work experience covered these topics. Summarizing paragraphs 13 through 20. My assignment for this hearing was to do this. Summarizing paragraphs 21 through 50. I have reached summarizing these paragraphs. I have the following opinions. Blah, 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 blah. 1, 2, 3, 4, not blah, blah, blah. And then perhaps some brief basis for those opinions. But that's what a summary means. It doesn't mean something new that they thought up of after they had submitted their thing. And I'm sorry if I'm ranting about this, but it's a frustration of mine. So having said that, and everything we've talked about, we now have CalAm and CEMEX proposing June 1 as a deadline, MCWD and the city proposing August 1. And you've all heard me say I want to get this thing moving. I actually was proposing in my mind yesterday when I was thinking about this, some dates before June 1, trying to move this on even faster. But On the other hand, I don't want you to rush so much that you don't have good quality written products. So having said all that, and my goal to get this matter moving forward and knowing we're going to have some real schedule conflicts during the summer, I'm going to start with you, either Mr. Moore or Mr. Asias for Cal-Am. Do you have any further comments on June 1 as to whether, based on all this, and knowing we're going to probably have depositions after you submit this, do you have any comments on whether you want to make June 1 earlier, later, or the same?
I would like, Bob Moore, I would like to keep it June 1, but that may change depending on what the next one is, our hearing date.
Well,
I'm
and
concerned the hearing date is far enough away from the last disclosure date, basically. We have enough time.
yeah, well, we're going to have some, it's going to have to be some time in here for depositions, unfortunately. I mean,
Yeah.
unfortunately, from a schedule point of view. Okay, Mr. Asias, anything further?
I just want to say, for the record, I agree with Mr. Moore.
Good. Mr. Newdecker?
No, nothing further.
All right, so, all right, for the city and MCWD, who wants to go first?
Well, I guess I'll do that, Mr. Lilly. I think that's really cramping. This is the heart of the case. We're getting this written testimony prepared and getting it in. So I thought August 1, as Mr. Moore had at one point stipulated to, I still think that's the best date. If we're going to have a hearing anywhere near mid-October, it's a perfect date because you can take the month of August for the depositions, and then there's about a month or 6 weeks for everybody to prepare, including you, for the cross-examination and the hearing. I don't know why we have to crowd this further. Right now, there's a trial set in June for the first two causes of action that Mr. Spalding has to worry about. The court hasn't vacated that trial date yet. I know that Mr. Brochard has a trial that's going to cost us about 6 weeks between now and June, and others may also. So I thought August 1 was a good date. I think that's very ambitious, and I don't want to put those ideas in your mind because you're being ambitious too. But having this finished from the time we started it, having it finished in October is kind of record time. For a reference, I think is a real record time. But
Well, if I can break a prior record, that's good.
that's good.
Before I go on to Mr. Spalding, I'm going to go, Mr. Osias's hand is up, and go ahead and answer your question. And
I was just going to comment.
Wait. Let me say something first, so you comment on it as well. Cal-Am has proposed or is proposing to build a project here, and I don't want to lose sight of the fact that I assume that delays in this process ultimately are going to delay how soon that project can go forward, if assuming everything falls into place so it actually can go forward. But I don't know if you want to add any comments on that to here. I mean, you can all say, well, it's just 2 months, but 2 months here, 2 months there ends up being a lot of time. I know Cal-Am is under a cease and desist order from my client, or not my client, but the agency I work for, the State Water Board. So, and this thing has dragged on for decades. So anyway, that's part of my concern as well. So with that, Mr. Osias, what are your comments?
So, well, the first is just that the trial date that was reserved a long time ago, the June 1, and it wasn't designated for any specific issues or pieces. So to the extent it's described as the city's bifurcated trial date, the judge said he wasn't vacating it, as we put in our statement at that last status conference, and somebody could seek to use it for that. It wasn't set for that purpose. I don't want that confusion. As to Cal-Am's schedule sensitivities, it's not through all of the regulatory approvals yet. Mr. Donlin also is quite familiar with that. I think it's fair to say Cal-Am's not indifferent to delay. It's all relevant. It all adds up. But I don't know personally what the regulatory approval completion date is and how a couple months might impact that or not.
All right, Mr. Donlin, you want to add anything on that? Mr. Osias to sort of raise your name.
Well, I do think the regulatory approvals are themselves uncertain, Mr. Lilly. But I think there is an interest in moving this particular proceeding along to remove one of the, at least one of the obstacles that is before us to build the project.
Okay. And that's, yeah, I mean, that's probably about all you can say based on the information you have in front of you now. So thank you. Mr. Spalding, I was going to come to you next for your comments on this. And I'll just say, from reading your joint statement, I'm sort of picking up with the idea that this June 20 trial date is almost certainly not going to happen. But it's still on calendar. So I'll tell you, I was thinking of, back before you all started telling me all the things you need to do, I was thinking that would be a great date for us to hold our hearing here and get moving. But I have a feeling I'd have a lot of very angry attorneys if I said that now. But anyway, Mr. Spalding, on step 3, submission of written proposed testimony exhibits, what are your comments? You'd put in August 1st, Cal-Am and CEMEX have put in June 1. What are your comments on that?
Thank you. I have a couple of thoughts. Number one, we're the plaintiffs, so we are interested in moving the case along as well. If I had to guess, I would say that the court will probably vacate or continue the current trial date. But the judge hasn't done it, so I'm reluctant to pick a date that would be in the middle of the trial. I have a couple of thoughts. Number one, maybe July 15th for the testimony would provide some time, or maybe in whatever your report is to the court at this point, you could mention that July 1 is the testimony date you're thinking of. If and when the court decides to vacate the trial date at the end of March. But we are in favor of moving up the date 2 to 4 weeks if it didn't interfere with the trial that actually goes.
Okay. Well, and just so we're clear, Mr. Spalding, I don't prepare a report to the court. What I'm going to prepare is a status conference order to all of you, and I send a copy of that to the clerk of the court, and I assume the clerk of the court, well, I don't know, but I assume the clerk of the court probably gives it to the judge, or one of you gives it to the judge. But anyway, I don't report directly to the court. I issue orders in this proceeding, but they get to the court. But that's not a major point. And I'll tell you regarding that, my inclination is I can set a date, a deadline, like June 1 still, or potentially something like July 1, and basically put a caveat in the order which says if the trial goes, if the court proceeds with the June 20th trial date, then I will extend that deadline. But that to me is the best way to deal with this when it seems, I think you're all saying it's pretty darn unlikely there's going to be a June 20 trial for the court. So I don't really want to have that influence our schedule more than necessary when it's so unlikely. All right, so with that, Mr. Wilkins, go ahead.
Picking up on your comments earlier on, Mr. Lilly, you indicated that setting a hearing in the summer would be difficult with attorney schedules, and I completely agree with that, knowing my schedule. And I also heard you say that you were tied up in September on other matters. So I guess my thought is if we're going to have the hearing in October, likely, which also works with the City of Marina's council's schedule, who's tied up in September, I don't know why we would jam ourselves to get testimony done when we don't need that amount of time between the testimony and the hearing date. So I think I heard Cal-Am's counsel say the timing of this testimony would somewhat depend on when the hearing date is. So I almost think it makes more sense to work backwards, because if we know when the hearing is going to be, it just seems to make a lot more sense to make that decision on when, if we have any benefit to jamming ourselves, or whether it just makes sense to keep the currently proposed dates that we have. And Callan previously stipulated to at the beginning of the hearing. So that's my.
I'm, at least in my mind, I'm working forwards and backwards, working forwards and then backwards, iterating back and forth a little bit. So, but thank you. I had thought if we couldn't do a June hearing, that potentially we could do a hearing in the first part of August. I'm just going to ask you, Mr. Wilkins, are you done? You can take down your electronic hand because I want to ask for people to put up hands now. If I were to set a hearing for the first and second weeks of August, would anybody have schedule conflicts with that? And you can just raise your hand electronically. Mr. Wilkins, why don't you just tell me what your conflict is if you can?
I have a prepaid vacation with my mother and family that first week of August.
I won't even ask where you're going, but I mean, it's great you're taking a vacation. We all need those. And I suspect of everyone on this call, probably none of you get enough of those. So I'm not gonna, this is the problem I have is summer just ends up being a problem. So I don't know whether you would, of course you have lots of very competent and experienced colleagues here, but I know you want to be involved in the hearing too. Anyone else having any schedule conflicts I hear for the first or second week of August? Mr. Brochard, go ahead.
So, Mr. Lilly, I don't personally have a conflict, but I don't know what our experts' schedules are going to be like in August. I know some of our experts are going to be very busy in the end of the summer, and it's going to be a challenge to get them all lined up just on the October date that we picked. I'm confident that we can do it, but we're going to have to pick the days that we fly them in, and they're going to be flying out pretty quickly because they're all very busy. That's
an added wrinkle. That's a very valid point, but a challenge. All right, Mr. Osias, your hand is up. Go ahead. I should never ask people about schedule conflicts because this always happens. Go ahead.
Well, and not quite as endearing as a vacation, but after 3 years of the pandemic, we're going to have a firm-wide all attorneys in-person meeting on Friday, August 5th, which in Southern California. So I believe Mr. Moore and Mr. Betts would have to travel on Thursday, August 4. There's both a all attorneys meeting and a partners only meeting that are stacked up on the day of the 5th.
That first week in August is looking worse and worse between you on Thursday afternoon and Friday and Mr. Wilkins on the whole week. So we'll see. All right. Well, let's go forward with the next question I have. That's my step 3.5. You all at least indicated you wanted to reserve the right to take depositions of expert witnesses, the expert witnesses designated by the other side. As I say, I think they'll should be able to be a lot shorter than they otherwise would need to be if you have written proposed testimony in hand before you take those depositions. But your attorney's trying to be thorough and issues you're going to want to cover. So I certainly have recognized that I'm going to allow a step in the process for expert witness depositions. And I'm also hearing there are going to be some challenges with scheduling those. So does anybody have any comments on how much time they would like or is necessary or appropriate between the filing date for the written proposed testimony, which includes exhibits, technical reports, and everything, my step 3, and when we start the hearing? In other words, how much time? I don't need to be involved, will not be involved in the deposition. So considering that you may need to have time to conduct depos, I'll just say, how much time do you think is appropriate between step 3 and step 4? And I've been starting with Cal-Am. I'll start with Cal-Am again. Mr. Osias or Mr. Moore, what do you think on that? You had put 6 weeks in your proposal. I don't know whether or not, well, actually all parties had put 6 weeks in their proposals roughly, but I don't know whether you'd thought about need to take depots in that time. So I'll just say, Mr. Moore, Mr. Asias, does the concept of taking depots between step 3 and step 4 change your 6-week proposal for the time between step 3 and step 4?
So I'll defer to Mr. Moore, although I'll just remind everybody that at least at the beginning of this hearing, my count was, as best guess, 8 experts.
Okay, and I'm maybe I'm getting a little tired here with my months. I see MCWD and the city have 2.5 months, August, September, and half of October, where CalAm and CEMEX have 1.5 months, June and half of July. So, and now, Mr. Osias, you just said approximately 8 experts.
Right. And we
I
had
can make some crack about them. Feel sorry for the person who's have to figure out all their testimony and the issues, but that's all right. Anyway, so with Mr. Moore, with that, back to serious comments. What do you think about the time between step 3 and step 4?
Hey, if we have 8 experts, I think that will take probably 3 weeks at the minimum. And that generally means a lot of cooperation between the parties and the experts.
Okay.
I think it could be done solely experts in 3 weeks.
Okay, and I'll just say something that may or may not be obvious. You'll have the names of the experts way earlier on than when you get their written proposed testimony. And you know they're going to submit stuff. So you can go ahead and schedule their depots. You know, you want to schedule them for dates after step 3, but you can do all the scheduling to get those on the calendar months in advance, which should help you some. You don't have to wait and say, oh, okay, now I've got the report. Now I want to take witness C's deposition. Let's figure out a date. Because if you wait that long, obviously it's going to be a lot harder.
Well, I was thinking the worst case scenario. I mean, if we had to really pack them into 3 weeks, excuse me, some period of time, what would that time be? And I think 3 weeks is what I think we could probably get them done in.
Okay, so assuming you could notice them to start fairly soon after the filing date, because you can read the report, have your expert read the report and tell you what questions to ask the other expert and so forth. And then time for the depots, 3 weeks minimum. I think that makes sense. Probably take more. And then of course you have to get the court report, assuming you still do it the old way with court reporters, you have to get them to prepare the transcripts and so forth. So I'm hearing 6 weeks minimum, and that's probably tight to do that. And then of course you need to prepare for trial, prepare your cross-ex questions for trial, which to some extent you can do ahead of time because you'll have the written proposed testimony. Your expert can tell you what questions he or she thinks you should ask the other party's expert, but the depot will help too. And I'll just say, I think you'll get more sympathy from me on what it takes to prepare for a hearing than a lot of hearing officers, because I did it so many times and I know how hard it is. And I also know that if you have time to prepare, you end up with much higher quality hearing participation, which we all want, of course. So, okay. So I think I've heard at least 6 weeks minimum. I guess I can see why Marina Coast and the city asked for 2.5 months, more like 10 weeks. So I think I've gotten enough input to try to hammer out my schedule here. What I plan to do is issue a pre-hearing conference order, which will set out my schedule with dates. And I also think I'll put in the post-hearing process dates. We haven't gotten to it yet, but clearly written closing briefs are going to be critical in this case. I mean, I have 2 very qualified technical people who are going to help me internal with the water board get through this. But the written briefs on the 9 or the 8 issues that the court referred to the state water board, it's going to be very important with citations to the exhibits and testimony. Clearly that's going to be important. So I anticipate allowing at least 6 weeks for that, just because I want those to be really good. And you want them to be really good. So I will put in at least that much time for those. And then, as I said before, we go through our process of preparing a draft proposed order, which will circulate to the parties for review and comments. And then we prepare a final proposed order, which goes to the water board. We have to use some slightly different terminology because the water code does require a draft order to the parties for references anyway, which this will satisfy that requirement. But those are the steps we go forward. So you can see why we get into 2023 pretty quickly here. So Mr. Osias, your hand is back up. Go ahead.
I apologize for that. I wanted to remind you, Mr. Lilly, that the rebuttal expert testimony may be very important, and putting into your post-hearing timeline when a rebuttal report or rebuttal testimony in writing would be required, and the opportunity for cross on that.
Thank you. I think I'd asked somebody to remind me of that. So thank you for reminding me. And again, that's something I've learned, that back in the old days, the water board used to just sort of go right into rebuttal after the hearing was over and just have it be all oral. And I think that ends up with a lower quality product than if I give you and your experts time to prepare a written proposed rebuttal testimony, not a long time, but at least a few weeks. And of course, you can start that as soon as you receive the other experts' written proposed testimony. Some of it you may need to refine after the hearing, but you can start that. But I would rather have another whole round. I do require your written proposed rebuttal testimony has to specify exactly what it is rebutting, because otherwise we get into arguments back and forth. Is this really rebuttal or is this new testimony, and so forth? But it's important to have that phase. So thank you for reminding me, Mr. Osias. I say again, this is not like, to use our football analogies for those of us who are watching the playoffs. This isn't like one party gets to kick a field goal right as time expires and they win. This is a hearing where we want to get all the evidence out, however much time it takes, so we can make an informed decision. So laborious as it is, we will go back and forth until everyone has had an opportunity to present what they think is relevant, within, of course, the scope of our process. So go ahead, Mr. Markman. Your hand is up.
Well, I've been listening to you, Mr. Lillian. Well, maybe offer a compromise on the dates rather than just have you out there without knowing. Having heard all this,
Go ahead.
I think we can back up our August 1st date to mid-July.
And that's just slowly. That would be step 3.
Step 3, and then even back up the hearing date to the 1st of October. Instead of mid-October. And
okay,
that we'd have the same period of time between those two dates to take the depositions. Just as long as I understand that you want to accelerate this, that would make sense. I think we could live with that.
Well, 2 weeks on a 2-year schedule is a little acceleration, I'll say. Thank you.
It's a little, when we don't want to go too fast.
Okay, well, and and if Mr. Moore or Mr. Osias or Mr. Donlin wants to say anything further on this, they may. I did mention earlier, separate from my process, I sort of have a general direction from my board, and I think from the court, to try to get this done. Certainly from my board, I know I do. But separate from that, there is a project that's being proposed here that it is in response to a water board cease and desist order. So not only does my board members, my supervisors, my 5 board members, want me in general to get things done, they have some specific interests here, and I have no idea how this project would fit into that cease and desist order, and they probably don't either. But I do know that there is a cease and desist order out there with deadlines, and that this project at least was being proposed potentially to address some of those deadlines. So delays, of course, make it harder to comply with those deadlines. Now, I suspect from the city and Marina Coast point of view, this isn't from what I can tell from the earlier filings, this isn't the project that should be built at all anyway. Of course, then there'd be further delays. So this is why water projects take a long time in California. Anyway, so I don't know, Mr. Osias, Mr. Moore, Mr. Donnelly, if any of you want to, I mean, your client is the one who's subject to the cease and desist order and ultimately is proposing to build this project. So do you have any comments on that, knowing that what we're looking at now, we're not going to get a state water board report or referee back to the court until, I'll say, spring-ish of next year, roughly, over a year from now.
So two things, Mr. Lilly. One is I think Cal Am would like to push this along as fast as reasonable. And two, and he'll have something else to add, but I think Mr. Moore may be the only person in this Zoom meeting who actually was on the field during a NFL football game and saw the last minute field goal.
Oh, okay, Mr. Moore, what was?
Unfortunately, a number of times, seeing that last minute field goal.
You've got me curious now. Were you a player or a referee or coach or what?
I was a player for 8 years.
Oh, who did you play with?
The Raiders.
Oh, okay.
Denver, over an 8-year period.
All right, well, what can I say? After that, being a lawyer is probably just seems like child's play in comparison.
Well, I only did it for 8 years. I've done this for 30 years. So
all right,
a little bit of a difference.
All right, well, I'm glad to see. It looks like you're still functioning with all your body parts. So I'm glad to see you survived your 8 years.
That's all right.
Excuse me?
I said below the waist, I'm missing a couple knees, but that's all right.
Okay, what was your position?
Tight end.
Okay, all right. I'm sorry, I just have to write that down.
All right.
No favorites or anything, but I spent my law school time in Berkeley, and the Raiders were really good back then. So
They were.
became quite a Raiders fan. Anyway, that's really digressing. Go ahead, Mr. Markman.
I just want to say that it goes without saying that Cal-Am is interested in their project, and we're a public entity in the Monterey area. We're equally interested in getting the water supply problem solved, but it shouldn't be lost here if you and I know, Mr. Lilly, you're going to read that whole complaint, that Marina Coast isn't doing this because they have an interest in interfering with water supply. We are concerned, seriously and in good faith concerned, about the future of our water source and what this project could do to it, as well as the prior projects, the prior agreements that were entered into that informed us we wouldn't be having this kind of discussion or litigation. So we'd like to see this resolved too, but not in a way where we're rushing to get the correct evidence in. And we realize we're going to be in 2023 on this reference. We didn't file the motion for reference. We were going through the process, the court process, looking at June hearing date. So we're not trying to rush you, is what we're saying.
You don't need to belabor that. And I did not ever intend to suggest anything to the contrary. I have read enough of your papers to know you have serious, and your client has serious and legitimate concerns about the impacts of this project, potential impacts of this project on Marina Coast water supply. And I certainly did not ever intend to suggest anything.
Yeah.
So anyway, Ms. Muzine, your hand is up. We haven't heard from you yet today. We're still morning. Good morning.
Good morning, Mr. Lilly. And not to digress into matters that may not be relevant here, but since you did mention the cease and desist order, you may be aware that the last operative date was December 31st, 2021, and Cal-Am, I believe, is in compliance and intends to continue to be in compliance with the Water Board's orders, with or without this project, and they have stated as much publicly and to the Public Utilities Commission, at least in writing. So I just wanted to point that out.
Mr. Lilly, is this the purpose of this get-together, is to take shots at my client?
No. It's my fault. I shouldn't have said anything. I just wanted to say that was a concern I suspected my board members might have about the schedule, but we don't need to argue back and forth. You'll have plenty of time to do that during the hearing. Probably a lot of what you've been saying today is not, well, I better be careful. The issue of where Cal-Am is in compliance with the State Water Board may or may not be relevant to this hearing. I'm not going to rule on that, but let's not go down there, because once we open that door, I think you're all going to think you need a lot to say. So please don't go down there. I'll just stick with my general comment that I have some directions to try to get this thing done, and I'm concerned about delays. And let's just leave it at that. So, Mr. Markman, do you have anything to say? Please don't say anything more about the issue that I inappropriately opened the door on. But do you have something else you want to say?
Oh, no, not at all. Thank you.
Okay, thank you. And I'm sorry, Mr. Moore, if I offended you or your client. I did not intend to do that.
No, you didn't offend us, I promise.
Okay.
Somebody else did, but you didn't.
All right. Well, and, I've said it before, I'll say it again. You're obviously all very experienced and qualified attorneys. You've been doing this for many years, and I have confidence you know how to work together where you can and to basically make it clear where you have disagreements on issues, some of them very stringent disagreements, and to present those. So let's go forward that way, and we don't have to, I'll say, digress beyond that. So anyway, Mr. Markman, your hand is still up. Are you still?
Oh, I'm sorry. No, that's just my incapacity at technical things like running computers.
Okay, fine. Somewhere there's a little hand icon you can click on that'll make it go away.
Got it.
Now you've raised your thumb.
Now
too,
I got
so
two of them. Oh,
you look like me trying to do the computer.
this is terrible. Okay.
All right. So is there anything else for today that anybody wants to cover? Let me just check my list. I think we've covered everything I have, and I'm sorry if it's been belabored a little bit too much. But I think we've covered all the issues. Just a reminder, if anyone has any updates to our service list, please send them to the AHO email address with copies to everyone on the current service list, and we will update the service list as soon as we can. So thank you all. I'm going to work on the schedule. Once we do have a schedule, we'll set appropriate dates for other status conferences and pre-hearing conferences as necessary. This is just a good way, at least for me, to receive input from all of you on these scheduling issues, which are very important, obviously. And if any of you thinks we need to have a conference earlier than what I will set, just send me an email again with copies to everyone on the service list and explain why you think we need an earlier conference and what dates you have in mind, and we'll go from there. All right. Thank you all very much for your patience this morning. Everybody have a good day and a good week. Goodbye.